addition to protecting the freedoms of speech, the press, assembly, and to petition government, the First Amendment forbids Congress from making any law respecting the establishment of religion or prohibiting the free exercise thereof. The first part, often called the Establishment Clause, forbids laws creating an official state-sponsored religion. The second part, the Free Exercise Clause, forbids government interference with people's freedom of religious worship. Thus, American civil liberties include both freedom from and freedom of religion. Perhaps surprisingly to Americans today, these principles did not apply to the states. For example, until 1833, Congregationalism was the official religion of Massachusetts. In drafting the First Amendment, the framers undertook a delicate balancing act. From its very beginnings, America was a complex mix of diverse creeds and cultures. This reality was reflected in Thomas Jefferson's 1777 drafting of the Virginia Statute for Religious Freedom, a notable forerunner of the First Amendment that effectively forbade the government from establishing an official religion. The Free Exercise Clause involves instances in which religious belief clashes with laws and has proved quite controversial. In Cantwell versus Connecticut in 1940, the Cantwells, who were Jehovah's Witnesses, were carrying out missionary work in a heavily Roman Catholic neighborhood. An anti-Catholic message on the Cantwells' portable phonograph provoked the anger of two pedestrians. The Cantwells were arrested for solicitation without a permit and for breaching the peace. The Supreme Court ruled that restrictions based on religious grounds were unconstitutional. The Cantwells' missionary message, the court said, did not entail any threat of bodily harm and amounted to protected religious speech. Another case, Wisconsin versus Yoder in 1972, involved the state's prosecution of 3 Amish families that refused to send their children to school past 8th grade, which was contrary to state law. The court unanimously found that the family's First Amendment right to the free exercise of their religion took precedent over the state law, since the values and teachings of high school ran counter to their religion. The court also said that the state failed to demonstrate that 2 more years of schooling would make a significant difference in the students' lives. In 2 additional cases, the court struck down laws that seemed aimed at particular religious practices. Employment Division, Department of Human Resources, Oregon versus Smith in 1990 involved 2 Native Americans who were fired from their jobs for smoking the drug peyote in religious ceremonies and then denied unemployment compensation because the firings were found to be based on their misconduct. When the state Supreme Court ruled that the law violated their free exercise rights, the state government appealed. The U.S. Supreme Court found in Oregon's favor, saying that free exercise rights do not prevent compliance with a valid law. Just 3 years later, the court struck down a city law that involved the free exercise of religion. The city of Hialeah, Florida, passed an ordinance banning animal sacrifice for religious purposes. Members of a church that practiced Santeria, an Afro-Cuban religion, sued to block the law. The court found in the church's favor, concluding that the law was not religiously neutral or applicable to the general population and was, in effect, aimed at one particular group. Although the Establishment Clause in the First Amendment has been widely accepted and adhered to, the Free Exercise of Religion Clause is much more unsettled and will likely continue to generate controversy.